Hello, and welcome to our webinar today, Intellectual Property Fundamentals. This is the first in our New York Small Business Development Center Business Learning Lab Fall 23 featured series on intellectual property in partnership with the United States Patent and Trademark Office. I'm your moderator, Jenny Alton, from the New York Small Business Development Center Central Office. Today's presenter is Elizabeth Dougherty, Eastern Regional Outreach Director. As the Eastern Regional Outreach Director for the U.S. Patent and Trademark Office, Elizabeth Dougherty carries out the strategic direction of the Undersecretary for Intellectual Property and Director of the USPTO, and is responsible for leading the USPTO's East Coast stakeholder engagement. Focusing on the region and actively engaging with the community, Ms. Dougherty ensures the USPTO's initiatives and programs are tailored to the region's unique ecosystems of industries and stakeholders. This webinar is hosted by the New York Small Business Development Center, which is a network of 22 campus-based centers and outreach offices, which are located across New York State, along with a central office based in Albany. The NYSBDC is a U.S. Small Business Administration resource partner. Our free advising, education, and advocacy services are made possible by funding from the SBA, New York State, and our host campuses. So you know, this session is being recorded today. We will share it with attendees along with slides after the webinar. Attendees are muted and will not appear on camera. Your chats will only be visible to myself, our presenter, and the other members of the USPTO team who are here to help today. If you have any questions during the presentation, please don't hesitate to type them in the Q&A box as they come up. You can open Zoom's Q&A box from the Q&A button at the bottom of your Zoom window. We have Harry Kim, Anna Murashan, and Tong Guo with us today to answer your questions as they come in. If you have further questions or need further information, there will be some contact information during the presentation that you will be able to use. You will also receive that follow-up email with the recording and slides from us at the NYSBDC, and you can reply to that as well. And with that, I will turn the time over to Elizabeth. Thank you again for being here.
Jenny, thank you for that kind and warm welcome. My team and I are super excited to be here with your audience today, super excited to be part of the NYSBDC Business Learning Lab of Fall series. And I hope that those of you who are tuning in today will also join us for the additional parts to this series, because each is going to bring a little bit of different information to the table, all of which we hope is helpful to you as you start and build and grow a business and learn about the role and importance of intellectual property in doing so. As was mentioned, my name is Elizabeth Dougherty, and I serve as the Eastern Regional Outreach Director of the U.S. Patent and Trademark Office. I'm a 32-year veteran of the USPTO. She's been my one and only, and it's been a pleasure to serve our country in helping inventors, innovators, and entrepreneurs to protect their intellectual property. We love our collaboration with the small business development centers, such as the New York Small Business Development Center, because they provide valuable resources to those of you who are looking to, again, to create and grow small businesses. And as you're going to see in our slides today, intellectual property is a key component of building and growing a small business. And we'll talk about that and talk about the various forms of intellectual property. So I am thankful to my team that is on with me today. And as Jenny mentioned, they will help to answer your questions in the chat as we move through our conversation. So with that, I am going to share my screen and we're going to jump right into the materials today. All right, moving my camera to my adjacent screen so I can look at each and every one of you, although you're not on camera. And we're going to jump into the materials, as I said. We've got a number of slides, but again, please don't hesitate to put any questions into the chat Q&A feature so that we can answer those during today's presentation. So we're here today to really kick off this conversation about intellectual property. And I know many of you may already be experts or at least have an appreciation of what is intellectual property and why is it important. But for some of you, this may be your first opportunity to dip your toe in the world of intellectual property. So let's do that together. In setting the stage, let's talk about what's inside the black box. And it is the black box of intellectual property. Because all too often, my team and I here, when engaging with individuals, organizations, small business owners, we hear that intellectual property protection is a rainy day project. It's a project that you undertake when you have more time or more money or a better appreciation. And that's really not your fault, because very few of us are ever taught about intellectual property. It's very infrequent that it comes up in school, even in graduate school. So it is something that, while it makes the world around us tick, we live the lives we do because of patented technologies and trademark registered goods and services, very few of us are brought to the attention of what is intellectual property and why is it important. So we're going to talk about that today. So our agenda today together is going to be talking about IP as a business strategy, IP meaning intellectual property. We're going to talk about what is intellectual property, who is the U.S. Patent and Trademark Office, and what are the basic forms of intellectual property, including trade secrets, copyrights, trademarks, and patents. We're also going to whet your appetite with some USPTO resources, which are again going to be highlighted in the next episode of this series. So jumping right into it, why and how is IP part of your business strategy? Why should it be? Why should you care? So looking at it from a 30,000-foot level, IP is attractive to investors and buyers. And how do we know this? What's a good example? For any of you who have ever tuned into the show Shark Tank, you know invariably those sharks ask those individuals and companies coming before them, have you patented your idea? Have you trademarked your name? Have you invested in protecting your intellectual property? So just one quick and good example of how IP is attractive to investors and buyers. It can also deter infringement lawsuits. And what do I mean by that? By letting the world know, particularly your competitors, that you are protected in your intellectual property, you can deter people from stepping on your intellectual property rights. And you do so by using the patent number on your patented device, by using the circle with the R, indicating a federally registered trademark, by using the circle with the C for a copyright that has been registered with the U.S. Copyright Office. You alert the world that you have created this and you have protected it. Just as IP is attractive to investors and buyers, it can increase leveraging power in mergers and acquisitions. It becomes a property right, just as real property rights, adding value to a company's assets. So a company, when it takes stock of the value in the company, they look at their hard assets. Do they have physical plants, facilities, corporate offices? Do they have a fleet of vehicles? What are their employees, their employee value? But they also look to their intangible assets, the intellectual property, as part of the property rights and assets of the company. And intellectual property is a global commodity. And we'll talk about that a little bit more specifically in the slides ahead. So what is intellectual property? Well, let's talk about it by juxtaposing it with real property. Real property is something that we can all appreciate. It is that tangible property that we own. We buy, we sell, we lease, we give to our heirs. It's things like a house, a car, a boat, that tangible property. It is what you purchase at the store. It is what you can sell. It is what you can own, again, lease, buy, assign to your heirs. Intellectual property is not that different in that it has those same properties, but it is intangible property. It is creative property of the mind created by an individual or group of individuals working together. And it is something which, like real property, brings value to an individual, an organization, a business by being something which can be bought, sold, licensed, given away. So as a representative of the U.S. Patent and Trademark Office, I am proud to say that we are America's innovation agency. We are committed to fostering innovation and economic growth through the creation of reliable, predictable, and high-quality intellectual property rights that are issued by the U.S. Patent and Trademark Office. The picture you're seeing there on our screen is part of our beautiful Alexandria headquarters office where my team and I are located. We have existed since 1790 with the issuance of the first patent and the creation of the first Patent Act. And while we're talking about history, let's talk about how intellectual property came to be a part of the fabric of our nation. It became a part of the fabric of our nation by the forethought of our founding fathers. When drafting the US Constitution, they recognized from a historical context, looking at other nations across the globe, that in order for us to have a strong and industrialized nation, we needed to provide for our authors and inventors the exclusive right to their respective writings and discoveries. This is enshrined in our Constitution in Constitutional Article 1, Section 8, Clause 8, which is known as the Patent and Copyright Clause. Now, trademarks are also enshrined in our Constitution, but more generally in the Commerce Clause. So again, this is something very deeply rooted and something that we have been pursuing and protecting since the very inception of our country in 1790. So what are the basic types of intellectual property, and what are you and I going to spend time talking about today? We're going to talk about patents, trademarks, copyrights, and trade secrets. And if you walk away with nothing else, I'd like you to know these 4 different forms, know that they protect very different things, and they protect them for very different durations. However, they can all play together, so to speak, in your creation of an intellectual property portfolio. So as you begin to start and build and grow a business, you may be creating one or multiple forms of intellectual property in your endeavor, all of which should become part of your quiver of intellectual property, become part of what you have value in your company in. Patents protect what we think of as new and inventive ideas, and there are several types of patents we'll talk about. Trademarks are the identifier of the origin of goods and services. Copyrights are the creative expression stored in a fixed intangible medium. And trade secrets are any information that is valuable and kept confidential in a business context. So again, we're going to talk about each and every one of these as we go through the materials today. Before we do so, though, I want to have 2 quick examples for you. So when I talk about an IP portfolio and that you may be creating multiple forms of intellectual property, let's take a quick look at the Apple iPhone. And you can see from this slide that in one iPhone, there are multiple forms of intellectual property, from trademarks, patents, copyrights, trade secrets, and design patents. And they all work together to protect this device. For example, trademarks, simply the name Apple. And we're going to talk more specifically about that when we get to trademarks. Patents may include the data processing methods, semiconductor circuits, chemical compounds, battery and power control, antenna, and the glass display. I heard anecdotally once that there are over 75,000 patented technologies in an Apple iPhone. I don't know if that's true or not, but anecdotally I've heard that said. Copyrights protect perhaps the software code, the instruction manual, and the ringtone used for the Apple iPhone. Trade secrets, well, of course, because they're kept secret, we'll never know what trade secrets are inherent in the Apple iPhone. And design patents can protect the form of the overall phone, the arrangement of camera lenses, and perhaps the placement of buttons and switches. So again, all of these in one commercially available device. Another example, one of my personal favorites, is the young inventor Marissa Strang. When Marissa was in the 3rd grade, she participated in a local invention convention in Florida. The challenge she sought to address was the fact that she had to wash the family dog, and invariably, when she washed the family dog, he would run about the house soaking wet. So she invented a device for drawing pets, and you can see her patent here on the screen. Bottom line, her device is a blanket, which when opened up has 4 leg holes. The animal's legs are put into the leg holes. The blanket is wrapped around the animal, velcroed up the back. There's a drawstring at the neck and a hosel where you attach a hairdryer. Marissa was not only awarded a significant cash prize for her invention, she was also featured on the Jimmy Fallon show featuring young inventors. So if Marissa Strang can do it when she's in 3rd grade, you can do it too. In addition to her patent, Marissa also has a federally registered trademark for her product, the Puff and Fluff, which again is the indicator of goods or services. So you know if you find this device, you know where it is coming from. She has a copyrighted website and, of course, her patent protected invention. So as we talk through the various forms of intellectual property, we are going to start today with trade secrets. Now, trade secrets, interestingly, are not part of the U.S. Patent and Trademark Office portfolio. They are something that is generally protected by the Uniform Trade Secret Act or through contract law between an employer and an employee. Trade secrets are incredibly valuable because of their possible duration. Trade secrets can last forever if the information is kept confidential, kept secret, and it continues to bring value to a business. Let's look at two quick examples. KFC chicken. What is the recipe for KFC chicken that makes it so delicious? Well, we don't know because they have managed to keep that recipe as a trade secret. And recipes are often examples used of trade secrets, whether it's the recipe for Coca-Cola or KFC chicken. Google is another great example because the algorithm they use for producing search results after you place in a few pertinent keywords is something that they have maintained as a trade secret. So why use a trade secret? Well, I've told you one reason, and that is the potential duration of maintaining your intellectual property. It could be forever. Now, the important things to keep in mind, though, is to be a trade secret, it must be protecting commercially valuable proprietary information. And again, that can be a wide array of things: formulas, business information, client lists, recipes that give a competitive advantage to the business. Trade secrets are not generally known and must be subject to reasonable efforts to preserve confidentiality. Now, what are reasonable efforts? Well, there's a lot of different things that could probably fall into that category. Do you keep the recipe in a locked drawer? Do you keep the recipe in a locked vault? Do you have the recipe divided such that no one employee has all of the ingredients and amounts in that recipe? Just a handful of examples. Now, common ways businesses or individuals lose a trade secret is failure to take adequate steps to prevent disclosure. You left the locked drawer unlocked. You left the recipe laying out on the desk. Perhaps somebody put it on the internet. Things like that happen. Owner or owner authorized disclosure, reverse engineering, and independent development. Those two can happen, and that is the challenge of deciding to keep your intellectual property protected as a trade secret. If somebody is able to reverse engineer your technology or independently develops it because it's such a great idea, they also come up with it too. There goes your trade secret because they now have possession of that confidential information. Moving right along, we are going to jump into copyrights. Copyrights are also not a part of the work of the U.S. Patent and Trademark Office. However, the USPTO does assist the administration in developing copyright policy for the nation. So we certainly do have a role to play, and we work very collaboratively with the U.S. Copyright Office, which is a part of the U.S. Library of Congress. So things protected by copyright, just like trade secret, it's a wide array of things such as songs, movies, books, sculptures. Creative works of authorship is what one should keep in mind. The duration of copyrights is the author's life, the creator's life, plus 70 years. And again, protect original works of authorship. Oh, I'm so sorry, bumped us back. So what is a copyright? A copyright is the intellectual property protection, the legal protection for the authors who create those original works of authorship. And again, it can be an individual, it can be a group of individuals. And this includes works such as literary, dramatic, musical, artistic, and certain other intellectual works. And we've got another list coming up to show you. So what works can be protected by a copyright? Because if I were there today with you in person, I would ask each of you to raise your hand if you have a copyright protected work. I would expect, you may not see this coming, I would expect you to all raise your hand, because if you have ever written a letter, a poem, a song, created something out of clay, and you have done so in placing it in a tangible and fixed form, you have in fact created a copyrighted work, because copyrights are what we call self-authenticating. By placing that creative work in a fixed and tangible medium of expression, you have obtained a copyright. Now, one of the things we're going to talk about, though, is the benefit of federally registering your copyright. Because by federally registering your copyright with the U.S. Copyright Office, you are availing yourself to additional protections and opportunities to protect your work. So again, keep in mind, by merely creating that creative work and placing it in a fixed and tangible medium, you have a copyright. So the fixation need not be directly perceptible so long as it may be communicated with the aid of a machine or device. So for example, if you place it on a thumb drive and it can be read with a computer, you have placed it in a fixed and tangible medium. Now, what works are protected? The next point to keep in mind is that it must be an original work of authorship, that the work must be independently created by the author, and it requires a level of originality which is low, a modicum of creativity, but it does require a level of originality. And I'll give you a unique example. I'll give you a little piece of homework too. Several years ago, there was a court case where the question arose, could a phone book be copyrighted? Did it have the required level of originality? Did it have a modicum of creativity that allowed it to be copyrighted by the creator? Again, I'm going to leave that to you as some homework to look up. It's a very interesting question. So again, what are some of the categories that can be protected by copyright? Literary works, musical works, sound recordings, dramatic works, choreographic works, pictorial, graphic, and sculptural works, motion pictures, and architectural works. So it's a wide array of creative endeavors that can be placed in that fixed and tangible medium that can be protected by copyrights. So as we said, the term of the copyright is the life of the author plus 70 years. Bouncing back to trade secrets, remember, those can potentially last forever. So the copyright has a fixed period of duration, and you'll see that in patents as well. So just keep that in mind. So what are the exclusive rights that fall to the copyright owner? You have the exclusive right to reproduce the work, prepare derivative works, distribute copies, perform the work publicly, display the work publicly, or authorize others to do so. And oftentimes it's in that last point, authorizing others to do so, where there is true value, because you can authorize others to do so and then sit back while they do the hard work of performing, displaying, creating, reproducing. So just to keep in mind. So let's talk about trademarks. As the U.S. Patent and Trademark Office, we are the agency that federally registers trademarks. And as you can see, the circle with the R is the indicator of a federally registered trademark. The TM, that goes to something which harkens back to the conversation we just had about copyrights. By using a mark in commerce, you inherently have a trademark. This is what is called a common law trademark. However, we want to encourage you to federally register your trademark with the U.S. Patent and Trademark Office if you intend to use your mark in interstate commerce, outside of a small or state geographic area. And you'll see why, because this allows you to take advantage of additional protections, as you also find with the copyright. So what is a trademark? And I'll take a quick sidestep here, because for those of you who are participating in our session today, you may be thinking to yourself, this all sounds well and good, it sounds interesting, but I don't really have anything protectable by intellectual property. I'm not creating intellectual property. Well, I would argue that any of you who are starting and building and growing a small business are in fact probably creating something protectable by a copyright, and certainly by a trademark. Maybe not by a trade secret or a patent, although I wouldn't rule those out. So keep those in mind as you pursue your endeavor. A trademark is any word, name, symbol, or device, or combination thereof, used to identify and distinguish goods and services, and used to indicate their source. And you see several examples here: Under Armour, McDonald's, Girl Scouts, Apple, Dodge. As you can see, as I've said, there are common law trademarks and service marks. That's the SM, although TM is more generally used than SM. And of course, the circle with the R to indicate a federally registered trademark. So again, what is the definition of a trademark? It is any word, slogan, symbol, design, or combination thereof that identifies the source of your goods or services and distinguishes your goods and services from those of another party. Let's take a simple example. Maybe you have created the next greatest breakfast cereal. Let's think about any time we take a trip to the grocery store and we take a trip down the cereal aisle of the grocery store. How many different types of breakfast cereal are there? There are a lot. I think we'd all agree. How do you know which one to pick up off the shelf? You generally identify with one that you like, either the flakes or the nuts or the clusters, and you know the one that you particularly like because maybe you've tried one or more than one, and you want to be able to go back and find that one the next time around because you enjoyed it. You are going to make that selection by using the trademark, because the trademark is going to lead you back. It is going to be the breadcrumbs that takes you back to that commercial product that you know and love, or maybe you've even just heard advertised on television or on the radio. Because trademarks identify the source of goods or services and distinguish them from the others that are sitting on the shelf next to them, whether it's a virtual shelf or whether it is the physical shelf in your grocery store. So I talked about having a common law trademark. You acquire the rights by using the mark in commerce. However, if you federally register that trademark with the U.S. Patent and Trademark Office, like with a copyright, you get to take advantage of additional protections. Brand recognition, distinguishing the goods or services from competitors in the marketplace, well, that works with both a federally registered trademark and a common law trademark. Public notice of ownership, by using the TM or the circle with the R, you are putting the public on notice that you have protected this brand, you have protected this identifier. Right to enforce nationally and bring legal action in federal court, that comes with the federally registered trademark. The use of the federal trademark registration symbol, that comes with the federally registered trademark. The right to record your mark with customs, that comes with a federally registered trademark. And the value there is that Customs and Border Control are going to help ensure that counterfeit goods do not come in the country with your mark on them if it is not something that you have authorized that it be identified under your trademark. A federally registered trademark can serve as the basis for foreign filing and allows publication in the U.S. Patent and Trademark Office trademark database, which is a great source for people to go to search as to whether a trademark is already in use. As you begin to develop the trademark for either the goods or services that you are creating, I would strongly encourage you to visit our trademark database, because maybe your idea for a trademark is just so good somebody's already using it, and you certainly don't want to infringe upon their rights. So types of trademarks. There are word marks, composite marks, special form marks, design marks. And then there's also some less traditional trademarks. Things such as sound, color, or smell. These are some of my favorite, I have to admit. The shape of the Hershey Kiss is a trademark. If we look at that robin's egg blue box, I think a lot of us recognize that it's probably something really beautiful from Tiffany's. Of course, when you see pink insulation at your local hardware store, you're going to know that that's coming from Owens Corning. When deciding upon a mark when protecting your goods and services, we would love to encourage you, as you look at this sliding scale, to have a trademark that falls within the category of fanciful or arbitrary, or suggestive, perhaps descriptive, but certainly not generic. Things, in fact, that are generic cannot be federally registered as a trademark. So let's look at some examples to kind of bring this point home. So what are examples of strong marks? Those that are fanciful are incredibly strong trademarks. They are invented words that serve no purpose other than to serve as a trademark. Words like Xerox, Microsoft, Cisco. These words, outside of serving as the identifier of the source of goods and services, have no meaning. Another one is Exxon. Outside of the indicator of the source of goods and services for petroleum products, Exxon has no meaning. The next strongest type of trademark is the arbitrary trademark, and that's where an individual takes an actual word, but that word doesn't convey any association with the goods and services. Apple for computer products and services. Yes, apple has a meaning in our common language. It's a fruit, as we all know. But when using it associated with computer products and services, it takes on a very different meaning and application. Gap and BlackBerry, two other examples. Suggestive trademarks have a medium level of strength and certainly can work as a good trademark. They suggest a quality or intended desire effect of the goods or services. Some examples are Coppertone, Dryfoot, and Ever-Ready batteries. Now, those examples of weak marks and the things we want to encourage you to stay away from are descriptive words. Words or designs that simply describe the goods or services. These are inherently not going to serve as strong trademarks and are going to be easy for others to step upon and infringe. Generic words, certainly common everyday names for goods or services, cannot serve as a source identifier and cannot be registered as a federally registered trademark. So again, why federally register your trademark? Nationwide protection. This allows you to use your mark in interstate commerce, meaning across the nation. Constructive notice of rights to use. The USPTO will refuse later filed applications that are confusingly similar, because that is the criteria that our trademark examining attorneys use when picking up and reviewing applications for federally registered trademarks. They are going to look to see if there is a likelihood of confusion for the consumer if we were to issue a new trademark. And I'll give you a quick example. Words can be used that are very similar for trademarks if they are in different categories of goods and services. For example, Delta Faucets and Delta Airlines. They are both the same word, they sound the same, they are spelled the same. However, the goods and services are in different lines of commerce. One is hardware and the other is transportation services. So federally registering allows you to use the circle with the R. Again, it allows you to prevent the importation of infringing goods by registering your mark with customs. It can be used as the basis for obtaining registration in a foreign country, and statutory damages and attorney fees are available in federal litigation relating to infringement. With that, we are going to jump into the world of patents. And again, we are the U.S. Patent and Trademark Office, so we are the agency in America that issues U.S. patents. So what is a patent? Remember, if we think back to that clause in the Constitution, the patent and copyright clause, it is the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. Patents, like copyrights, are for a limited term, and that limited term depends upon the type of patent. For utility and plant patents, and we're going to talk about those, it is 20 years from the date of earliest filing. For design patents, we'll talk about those too, it is 15 years from the date of issuance. Patents, like all other forms of intellectual property, are territorial. They only provide protection within the country that issues those rights. So there are no worldwide patents. Just keep that in mind. I will say, in looking at this slide, it occurs to me that I failed to tell you what is the term of a trademark. So I'm sorry to bounce back to trademarks for one quick minute. Trademarks, like trade secrets, are incredibly valuable because they too can last forever if, and I say if, the mark is continually used in commerce and one continues to renew the mark with the U.S. Patent and Trademark Office every 10 years. So with that, let's get back to patents. So as I said, there are 3 different types of patents, and they protect 3 different types of inventions. Utility patents protect what we think of as inventions, whether it's a bicycle, a new cellular communication device, or maybe a new mousetrap. They protect how an invention works, functions, or is made, and are good for 20 years from the filing date, the earliest filing date. and they protect processes, machines, articles of manufacture, compositions of matter, or improvements thereof. And it might be interesting to note that 99% of patents that are issued today are for improvement technologies, things where individuals are building upon existing technologies. Arguably, only about 1% of patents are for truly disruptive technologies, things we've never heard or seen of before. I will let you know that the U.S. Patent and Trademark Office receives over 650,000 patent applications each and every year and issues over 325,000 patents each year. So that's a lot of good innovation going on. I hope that you're part of that. Design patents protect the way a product or article looks. They protect the ornamental appearance of an article of manufacture, and they are good for 15 years from the date of grant. If you think back to our example of the Apple iPhone, that Apple iPhone was protected by both utility patents and design patents. So if you are creating a commercial product, keep in mind you may want to both seek a utility patent and a design patent. Great conversation to have with your intellectual property professional, whether they're a patent attorney or a patent agent. And last but not least, we have plant patents, which protect newly invented strains of asexually reproducing flowering plants, fruit trees, and other hybrid plants for 20 years from the earliest filing date. So when determining whether or not to apply for a patent, one must first consider, is your idea eligible for protection? Is it patentable in the sense that does it fall into one of these statutory classes of patentable subject matter? I know that sounds like a mouthful. The question is, have you invented a new and non-obvious process, manufacture, machine, composition of matter, or improvement thereof? And that's kind of the beauty of the US patent system, is that this repository of patented inventions, and we've issued over 11 million patents, they serve as the basis for the growth of new technologies. So in addition to determining whether or not your subject matter is patent eligible, an examiner, if you were to file an application, is also going to make the determination of whether your invention is novel, meaning is your invention new and not described in the prior art. Now, when I say prior art, what do I mean? Prior art is just a technical way of saying published and publicly available information that is available prior to the date of your invention. Now, our examiners, our U.S. patent examiners, have a wealth of resources at their fingertips to do prior art searching, to look the world over to see if your invention is novel, and we're also going to talk about non-obvious. So they have incredible access to electronic databases to find things, again, that are published and publicly available that are pertinent to your invention. So whether it's previously issued patents, pending patent applications, foreign patents, senior thesis documents, trade publications, internet websites, if it is published and publicly available, our examiners can have access to it to determine whether or not to issue you a US patent. The other and perhaps hardest criteria for an examiner to do when evaluating an application for patent is your invention non-obvious? Meaning, are the differences between your invention and previously known inventions, would it have been obvious to someone in that field to have combined references or to have come up with your invention? And that's a pretty tough determination to make. And that's why we have over 8,000 trained engineers and scientists that are doing the work of US patent examining every day of the week. Last but not least, the question arises, does your invention have utility? Meaning, does it function as intended? It's a pretty low bar of entry, just as copyrights require a low modicum of creativity. Generally, things have utility. I'll give this simple example of a cap or a hat. Protects your head from the rain and from the sun, so it certainly has a utility. Things like perpetual motion machines really fall into that category of things that do not have utility. You know what? We have been issuing patents since 1790 when we issued the first patent to Samuel Hopkins, the inventor of a method for making pearl ash and potash. And we've issued patents for a wide variety of things. People seek to find solutions through patents addressing the challenges that their families, their communities have. As you can see, here's two very early examples of individuals that are solving the age-old problem of fire escape. So whether it's the fire ladder of James Johnson or the fire escape of B.B. Oppenheimer, people have been addressing the challenges of fire escape for many, many years. One of my personal favorites is, of course, the readily portable burrito by Eddie Bernal in 1983. In case carrying a burrito in and of itself wasn't easy enough, we added some means to have it more readily portable. So what is not patentable? What cannot be patented? One cannot patent an idea. And what do I mean by that? Well, I'll give you an example. I have an idea, and I think it's a great idea. I would love to invent a time machine. So the question is, can I receive a patent on my idea of creating a time machine? The answer is no, because your invention, you must be in such possession of your invention that in your patent application, you can describe it with such specificity that others can make and use your invention. So you must be able to put into writing the new, non-obvious, and useful machine manufacture process or composition that can actually accomplish the task. I do not have the technical wherewithal to write a patent application that describes the technology required to travel through time and meet remarkable people. As sad as I am, I do not have that ability. It's a great idea. It is not an invention. You also cannot patent natural phenomenon or abstract ideas. So what is the path to a patent? Well, it has several steps. And of course, it starts with an idea. And that idea may be, again, a solution to a problem in your life, the life of your family, the life of your community, or the world in general. Now, one of the steps in the process can be something called a provisional patent application. And we're going to talk about that in our next slide. In order to receive a U.S. patent, however, one has to file the non-provisional patent application. That is what is examined by one of our over 8,000 U.S. patent examiners, and that is what can result in a U.S. patent. So very quickly, what is the provisional patent application? This is a useful tool that serves as a placeholder for you to have something on file with the office, to begin to use the term patent pending, and to begin to talk about your invention, talk about your idea with others with a slight level of protection in place. Now, can you sue somebody based on a provisional patent application? No. You can only sue somebody for infringing upon your invention once you have your patent in hand. However, this allows you to put something on file, which is maintained confidentially, and again, allows you to use the term patent pending. It is only good for 1 year. We will only hold it for 1 year. It is only available for utility patents, not examined or published. It is a low cost of entry and a low bar of entry. It can be used as the basis for your non-provisional. And for any of you who are thinking about this, again, this is a definitely good concept to discuss with an intellectual property professional. Which, to that point, I want to tell you that you are not required by law to use an intellectual property patent attorney or patent agent to file a patent application, but it is strongly encouraged because of the complexity of doing so. So what does the patent application process look like? Well, very honestly, it is a process of communication and collaboration with the U.S. Patent and Trademark Office. You're going to file your application either yourself or through the help of a registered patent attorney or patent agent. It's going to go into our office and it is going to be assigned to a U.S. patent examiner who has a wealth of experience in that technology area. Our examiners are divided into electrical, chemical, and mechanical and design. So we will route your application to that examiner who has the best background to give your application a thorough examination. It's then going to become a back and forth conversation. Keeping in mind, we want what you want. We want to issue you a valid patent that you can take to the bank and not to the courthouse. Now, with that said, not every patent application is going to result in a patent. On average, about 50% of applications result in an issued U.S. patent. Now, there may be several communications throughout the way where there are rejections and objections, amendments and arguments, but it is all part of the process. And I say that because I don't want you to become frustrated. If we send you a communication that includes rejections and objections, don't fold up your tent and just go home. I'll go back to the example of Marissa Strang and the pet drying system. She received a communication from the U.S. Patent and Trademark Office where we said her specification was objected to, her drawings were objected to, and her claims were all rejected. But we know how her story ended. It ended with a U.S. patent. And that was through the help and perseverance in working with an intellectual property professional to arrive at subject matter that was patentable. So as I said, as I promised, I want to whet your appetite with some resources. And again, this is going to be reiterated in the next iteration of the series. First and foremost, for those of you who have not visited us at uspto.gov, I strongly encourage you to do so. And those of you who have visited us, I encourage you to come back because we are always updating our website with new and valuable information. What you're seeing here is a screenshot of our homepage. And to tell you where I would start if I were jumping into uspto.gov, I would start with the Learning and Resources pull-down tab, which you see along that top toolbar. That's where, to me, you're going to find all of the good stuff of an inventor, innovator, and entrepreneur and able to get started. The journey of innovation is something that we change each and every month, and it is an opportunity for storytelling about successful inventors, innovators, and entrepreneurs who have used their intellectual property to grow and start a business, to create an industry. And they come from a wide diversity of backgrounds and a wide diversity of opportunities. So I encourage you to read those stories because they're each fascinating. Finding help in your area. This is a really great conversation to be had. As you can see, and as I mentioned, my team and I are located at the Alexandria, Virginia headquarters. And my team and I, we serve the entirety of the East Coast, engaging with inventors, entrepreneurs, and innovators of all walks of life, whether students, individuals, small businesses, legal organizations, colleges and universities. We love to engage with them all. We also have regional offices in Detroit, Denver, Dallas, and San Jose. Now, with that said, we also have, if you go to the map of finding help in your area, we also have a number of other resources that are available in your area that you'll find when you go to, for example, the state of New York. One of those resources you are going to find is a listing of the patent and trademark resource centers in your area. The PTRCs is a network of over 80 libraries located nationwide at free libraries, generally college or university libraries, where there is one or more trained librarian who is gifted in teaching patent and trademark searching. As I said, you're not required by law when filing a patent or trademark application to have conducted a search, but we strongly encourage it. Maybe your idea is just so good, someone has already thought of it. Now, just because you haven't seen it on the store shelves or on Amazon, it doesn't mean it isn't already protected by a patent or a trademark. So taking a little time for a high quality patent and trademark search is always strongly encouraged. For the PTRCs in the state of New York, I'm going to let you know you've got several of them, so you're very, very fortunate. There's one located at the New York State Library. That's in Albany. There is one at the Buffalo and Erie County Public Library in Buffalo. There is one located at the Science, Industry, and Business Library in the New York Public Library of New York City. There is one located in the Central Library of Rochester and Monroe County in Rochester, and the Smithtown Main Library in Smithtown. So you have 5 out of the over 80 PTRCs located in the state of New York. Congratulations, New York. You can also, when you go to resources in your area, find out information about our free legal assistance programs, and we have 2. One is our patent pro bono program, and there is a corollary, the Law School Clinic Certification Program. As a result of the America Invents Act of 2011, the USPTO was directed by Congress to work with legal organizations across the nation to stand up state and regional patent pro bono programs to ensure that under-resourced, financially under-resourced inventors were not leaving inventions on the kitchen table or the garage workbench because they could not afford to bring these inventions forward. So we did just that. We've stood up state and regional programs covering the entirety of the nation with patent pro bono programs. I will let you know that for New York inventors, you are served by the New York Tri-State Program. And that program matches inventors who qualify with volunteer attorneys and patent professionals that will help you file your patent application. Now, the law school clinic certification does a similar approach because it empowers law school students under the supervision of a supervisor to practice patent or trademark law. It not only helps us to grow that next generation of intellectual property practitioners, but it also provides additional low-cost or free legal assistance to individuals who are financially under-resourced. In the state of New York, you have the Syracuse University College of Law Community Development Law Clinic, which provides trademark services. The Fordham Law Samuel Glushko Intellectual Property and Information Law Clinic, which provides free or reduced cost patent and trademark assistance. You have the Brooklyn Law School Clinic and Brooklyn Law Incubator and Policy, which provides patent assistance. And there is also the New York Law School PTO Clinic, which provides assistance in patents and in trademarks. So again, in New York, you have a wealth of resources available to you for free or reduced cost legal services if you qualify. And there are several criteria in which you have to qualify for, meaning one is that you fall under a certain financial cap, that you show that you have more than a mere idea, and that you put some skin in the game. And you can put some skin in the game by taking both either a virtual class on our website, or by filing your own provisional patent application. But I encourage you to visit our website to find out more about these programs if you think that you might qualify. We have another great tool on our website, and that is the IP identifier tool. By using our IP identifier tool, answering a series of 6 questions, you can find out some basic information about the forms of intellectual property that you might be creating in whatever endeavor you are undertaking. Inclusive innovation, I'd be remiss if I didn't tell you that the USPTO is looking to empower and broaden the world of those who see themselves as able to participate in invention, innovation, and entrepreneurship. And we're doing it by partnering with academia and industry to really broaden that world. Because if we don't, we're competing against the rest of the world with 4 fingers and 1 hand tied behind our back. We need all Americans to see themselves as able to participate. One of my favorite places on our website to direct people to is our inventor and entrepreneur resources. I love this because I feel like it really is that one-stop shop, providing information in kind of a chronological fashion of what you need to know as you get started. It starts with getting started, all the way down to protecting yourself once you have your intellectual property rights in hand. Strongly encourage those of you who see yourselves as inventors and entrepreneurs to see this as a great starting place on our website. Additionally, for those of you who are startup companies, we also have a one-stop shop that provides you with some additional startup-focused resources, protecting your IP rights, planning for success, finding funding, and engaging experts. This page leads you to some resources that are both USPTO focused, as well as some that are outside of the US Patent and Trademark Office, including a link to our friends at the Small Business Administration. Now, let's say you were jumping into the process either in filing a patent application or filing a trademark registration, or maybe you've already filed, or maybe you've even received your patent or trademark and you have questions. Well, I'm happy to say we have an Inventor Assistance Center and a Trademark Assistance Center that are staffed Monday through Friday, 8:30 to 8. They welcome your phone calls, they welcome your emails, and are happy to take your questions. These 2 teams are staffed by individuals who have had lengthy careers at the USPTO, oftentimes 30, 40-year careers, individuals who are looking to continue to give back to those of you who are starting out and seeking to protect your intellectual property. One pilot program I'd like to call to your attention because it is relatively new and we're excited for people to take advantage of is our first-time filer expedited examination pilot program. And this is for those of you who are filing your very first patent application. With this first-time filer expedited examination pilot program, if you are a financially under-resourced applicant and this is your first patent application, take a look at this program, because what it does is if you qualify for the program, when you file your application, it will be taken out of turn, taken out of the backlog and assigned to a patent examiner, so you get a decision much more quickly recognizing that if you are under-resourced and needing some quicker results, this is going to help you to have those results so you can begin to pursue your endeavor. So when I say special status until first office action, that's what I mean when I say your application will be taken out of turn. Because remember, we receive over 650,000 applications each year. So your application is going to be sitting in that backlog until it is picked up in turn for examination. This pilot program will take it out of turn. We have a similar program for those of you who are inventing in the area of climate change, particularly for those that reduce greenhouse gas emissions. It too takes applications out of turn and advances them to examination. Reduced patent fees, I want to be sure to call out for those of you who qualify as either a small entity or a micro entity. Please take advantage of these. Please please call out this status when you file your application. Our small entity applicants pay fees reduced by 60%. Our micro entity applicants pay fees reduced by 80%. Keep in mind for that micro entity status, it's not enough to just call yourself out that you qualify as micro entity. You must in fact file a statement. There is a statement required, and you can find more information on our website. And there are several qualifying factors for that micro entity discount. Many less for our small entity, as you can see from the slide in front of you. Just as you're attending an event today, I want to draw your attention to the wealth of events hosted by the U.S. Patent and Trademark Office every Monday through Friday on a wide array of topics. You'll see that we discuss many things, including protecting your IP abroad, to how to conduct a patent or trademark search. We also offer things for our K through 12 educators, our intellectual property professionals, and just curious information relating to intellectual property. So I encourage you to tune in with us any day of the week by visiting our events page, where you can find the listing of all events that are taking place. Another way in which to stay connected with the USPTO is through our subscription services, and we have over 12. You're welcome to go on our website, put in subscription in the search box, and you'll find the list of those that you can sign up for. Sign up for one or all and receive information dropped into your inbox when we have something significant to say. We will not sell or give away your contact information, and we will only drop something in your inbox when we have something significant to say. With that, we have ended just in time, and I know my colleagues have been sharing information throughout our conversation today. I leave you with our social media handles, as well as my name and email address, and the email address to reach my team, Eastern Regional Outreach Office at USPTO.gov, and that is the direct line for the Eastern Regional Outreach Office. So just letting you know that we welcome continuing to be a resource for you. I am going to stop sharing and turn it back over to Jenny as we finalize the last minutes of our time together. Jenny, all yours.
Wow. Thank you so much for all of that information today. In the words of one of our attendees, that's a lot of information for first timers.
Indeed, it is.
Thank you for that excellent and very thorough introduction, Elizabeth. And to our attendees, fear not, you will receive a follow-up email with a link to this recording and a link to the PDF of the slides as well, so that you can review this information as much as necessary and find those pieces that are applicable to you in your business journey with your intellectual property right now. We kindly ask, if you have a few minutes, that you take the follow-up webinar survey that will display when I shut the webinar down today, and will also be linked in that follow-up email. If you have questions related to this webinar, you can always get in touch with the USPTO through the contact information they have shared today. You can also reply to that email, and that will come to us at the NYSBDC, and we are able to connect you with the USPTO and answer questions that you have in regard to starting a business around intellectual property. And with that, we will shut things down. So thank you again to everyone for attending today, and we hope you have a lovely rest of your day.
Thank you, Jenny.
Thank you. And thank you to those behind the scenes helping today.